You may have heard that over time, creditors can't chase you for debt. The statute barred law means that after a certain time frame, if you've had no contact with creditors and made no payments, then they can't take you to court anymore. Every debt has a ticking clock called the limitation period. And once this clock runs out, the creditor can't legally enforce you to pay the debt. In places like England or Wales, this timer generally lasts 6 years. And in Scotland, it's 5 years. But it's never that clean cut, is it? There are nuances. So statute barred debt are debts that haven't been paid within that limitation period. In Scotland, it's got another name. It's called prescribed debts. But the frustrating part is that certain actions can reset this limitation timer. Imagine playing a board game and getting sent back to the start. Well, that's essentially what happens if you make a debt repayment or even just acknowledge the debt in writing. And for those sharing a joint debt, if a payment is made, both of your clocks reset. But if only one person acknowledges the debt in writing, only their clock goes back to 0. Different types of debts have their own rules. Statute barred debts are those old unpaid debts which have outlived their limitation period. But which debts are we talking about? Well, the most common ones include overdrafts, credit cards, catalogue debts, and a majority of unsecured loans. Just to quickly describe unsecured loans, they're those without any collateral like a house or a car. So if you've defaulted on loans like this, the creditor has got about 6 years to chase you legally for it, starting from the default notice or your last acknowledgement. Mortgages don't fall into the 6-year bracket. You're looking at a 12-year period for the borrowed capital. However, any interest charged is set at 6 years. It's confusing, isn't it? If you've had a personal injury claim, well, that's got a quick 3-year limitation period. And debts like income tax, VAT to HM revenue and customs have no limitation period, meaning they can chase you forever. If a creditor reaches out claiming the debt's still valid, remember the ball's in their court. They need to prove its validity. Ask for evidence like a payment receipt from the last 5 years. And if they can't prove it, well, that debt is officially statute barred. Now, here's a common misconception. If a debt disappears from your credit record, a lot of people believe that it's automatically statute barred. That's not the case. Remember, your credit file is like a 6-year photo album. It only keeps records of the last 6 years. This doesn't mean that the debt's statute barred. It's also crucial to understand the differences in different regions. So in Scotland, once a debt is prescribed or statute barred, it's as if it's evaporated. But elsewhere in the UK, the debt still hangs around, just lurking in the background. If you're feeling proactive, you can request this debt to be written off, but proceed with caution. If the debt isn't genuinely statute barred, you could unintentionally reset that limitation period. Something else to bear in mind is that even though you can't be taken to court for these debts, they can still stay on your credit file. This will have a negative effect on your credit rating, making it difficult to get credit or access to lower interest rates. The most difficult part of statute barred debt is working out when the time limit starts. According to the UK Statute of Limitations Act in 1980, the timer kicks off from the cause of action. So in simpler terms, for some debts, it's when your agreement states that the creditor can chase you in court. For others, it's post a default notice expiration. Keep in mind, most debts like payday loans or credit cards typically become statute barred after a 6-year period or a 5-year period in Scotland. If you've received a letter about a statute barred debt, don't panic and definitely don't ignore it. Respond, but just be so wary about your words. Avoid admitting liability, as a wrong phrasing might be perceived as acknowledgement and, of course, resetting that clock. And on the topic of court-related letters, always address him. Prove that the debt is statute barred to prevent court decisions against you. If debts have in fact built up and you don't think they do fit into the statute bar category and you're financially struggling, you might want to look into debt solutions. To be honest, they all come with their own pros and cons, and it's best to look into all of your options before you make any decisions. Now, some of them can lower monthly payments, others can even write off some of the debt. And I'll leave a short form for you below this video, and if you complete it, you'll be connected to a company that I've partnered with to discuss what options are available to you. Statute barred debt is usually 6 years, depending on the type of debt, but look through bank statements, your inbox, and through that full drawer that you keep all of those letters in. And if you're unsure, consult a free debt charity like Step Change and explain your situation. Just remember not to get back into a paper trail in case you reset the statute barred clock. Good luck.